Seated and quiet. The Honorable Paul C. Ridgway, President Rosado. Good morning, Your Honor.
Good morning. Good morning.
Good morning. When Your Honor is ready, I have two housekeeping matters.
Yes, ma'am.
Yes, Your Honor, just two very brief housekeeping matters. We have put both parties' closing statements on a thumb drive to put into the record so that somebody following along with the closing statement can see what was being looked at and talked about. I have labeled it Defendant's Exhibit Closing, and I would like to hand that to the clerk.
All right.
The other very brief housekeeping matter, Your Honor, is you might have noticed I'm a little cautious about making sure the record is clear. I don't think it's necessary, but just to be clear, we believe that a sentence of life without parole would be unconstitutional as applied to Austin Thompson under the 8th Amendment and Article 1, Section 27 of the North Carolina Constitution.
So noted.
And if I may approach the clerk.
Yes, please.
Thank you. Thank you.
All right. Good morning again, ladies and gentlemen. Thank all of you for your participation and professionalism throughout these proceedings. I particularly thank counsel for the informative and professional way in which each of the counsel have conducted themselves under these difficult circumstances. I also commend those of you who are in the gallery for your professionalism throughout these proceedings so that we can conduct these proceedings in a way that befits the gravity of the situation but also achieves the ends of justice. Before I get into the details of sentencing in this matter, I too also, like the state in its closing argument and the defense in its closing argument, like to simply just redirect the attention for a moment on the victims of this case. This is certainly an important day for them as well. These proceedings are important. They reflect the constitutional rights that the victims have the right to be present and to be heard at proceedings like this. And I want to just say briefly a bit that I learned about each one of the victims. What I learned about Lynn after 3 months in the hospital, life support, her mouth wired shut, buckshot fragment found in her body, 5 buckshot fragments found in her body, 1 remaining, parts of her internal organs removed. She, our first witness, sat on the witness stand and said that God has given her the grace to forgive the young man that shot her. Reflects a beautiful soul. Nicole, what struck me was she was loved so fiercely by her husband that the defendant's actions have broken him. He doesn't enjoy things like he used to. He feels socially awkward. He doesn't like to go anywhere because he feels guilty about having fun without his wife. Gabe, former U.S. Marine, Raleigh police officer, a really great husband and father. We heard a powerful statement from Jasmine about the impact this has had on her. And Layla, Gabe's daughter, knows her father only through photos, videos, and a cutout pillow with his image on it. Casey Clark, Raleigh Police Department for 10 years, a member of the Selective Enforcement Unit, the SWAT team. His entire life goal was to be on that unit. It was his dream. He was only able to live that dream for 3 years before, while protecting the citizens of our community, he was shot in what felt like a freight train going through his knee. He's not able to continue in the law enforcement profession and still has a bullet in his leg. James Thompson, son of Elise and Alan Thompson, honor roll student, 4.12 GPA, saving money from his odd jobs for a car in college, all-around athlete, excelled in team sports, a good son, couldn't ask for anything better. Sue, a runner, marathoner, ultra-marathoner, mother of Max, Oliver, and Everett. Every day when her husband Tom wakes up, he realizes his wife is not there, lying beside him, and that makes that day hard. And he knows that that will be his experience every day for the rest of his life. Mary Beth Marshall. I really love Jenny's description of Mary Beth as the home entertainment system of their family. Singing loudly, off-key, silly jokes. And I really like this description. She had laughter that can only be described as what sunshine sounds like. We turn our attention now to the sentencing in this case. And I'll start with a brief statement of the law that governs the task of the court with respect to this sentencing hearing. There was a little disagreement about what the law actually is in the closing arguments. In 2025, the North Carolina Supreme Court in State v. Sims said, quote, "The inquiry is not whether a defendant is permanently incorrigible or irreparably corrupt, nor is it potential for redemption." End of quote. Both the United States and Supreme Courts hold that life without parole should be reserved for the rare juvenile offender whose crime reflects irreparable corruption. So the purpose of this hearing is to answer that question. Is Austin Thompson the rare juvenile defendant whose crime reflects irreparable corruption? When a juvenile, as Mr. Thompson was at the time of these offenses, has been convicted of first-degree murder on the theory of premeditation and deliberation, the sentencing court must conduct a sentencing hearing to determine whether a sentence of life without the possibility of parole is warranted. At this hearing, the defendant or defendant's counsel may submit mitigating circumstances to the court, including but not limited to the following factors: the age at the time of the offense, immaturity, ability to appreciate the risks and consequences of the conduct, intellectual capacity, prior record, mental health, familial or peer pressure exerted on the defendant, likelihood the defendant would benefit from rehabilitation and confinement, and any other mitigating factor or circumstances. A sentencing court is required to consider any mitigating factor presented, and its sentencing order shall include findings on the absence or presence of any mitigating factor and such other findings as the court deems appropriate. Our Supreme Court has explained that it is the adherence to the sentencing procedure, the consideration of the murderer's age, diminished culpability, and heightened capacity for change that helps ensure that life without parole sentences are imposed only in cases where the sentence is appropriate. Over the past 2 weeks, this court has done exactly that. We've conducted a sentencing hearing to determine whether life without parole is warranted. The court has received and carefully considered all mitigating circumstances presented. 39 witnesses have been called: experts, eyewitnesses, parents, teachers, law enforcement officers, detention officials, and victims. A frequent question throughout this hearing, and not at all surprisingly, has been the search for why these crimes were committed. That is an important question for many reasons, but the answer is not required by law. The motive of a person to commit horrible crimes is sometimes illuminated by circumstances of the crime, by the evidence, but sometimes the motive may never be known with certainty. Under the facts of this case, where the result of the self-inflicted traumatic brain injury, the evidence suggests that the defendant cannot remember why he did these things and has not articulated his motive to the experts who evaluated him. As such, the evidence that sheds light on the defendant's motivation, planning, and intentions must come exclusively from the written record and other circumstances that he left behind. His internet search histories, the notes he left after killing James, the notes secreted in the chapstick tube in defendant's room. The court finds that this evidence, namely the defendant's own written record, is reliable and probative in this inquiry. I will not at this time recite in detail each of the findings and conclusions that I ultimately will reduce to a written order in this case, but I do want to take the time to provide some context for the sentence that I will be imposing on Mr. Thompson and address some of the major issues that have been presented in this evidence. First, the court finds and concludes that defendant's criminal acts were the product of defendant's malice. The court begins by considering the evidence of defendant's criminal conduct, and in particular the factual circumstances of each of the 5 homicides which give rise to the possibility of a life without parole sentence. This is, of course, relevant in understanding whether the crimes committed reflect irreparable corruption, as is the mandate of the Supreme Court to this court. Each of the 5 homicides was perpetrated in a manner that reflected utter and callous disregard for human life. Defendant shot James in the head from a close distance, and then, despite his mortal wound, dragged James into the bathroom and mutilated him with over 57 stab wounds to the neck. Defendant then selected 2 weapons, a 9mm semi-automatic pistol and a shotgun capable of holding 5 shells at a time. For the shotgun, defendant chose double buckshot shells, each shell holding 8 or 9 pellets the size of 9mm slugs, ammunition designed to cause devastating damage. Defendant then dressed in camouflage, packed a survival bag, stockpiled over 100 rounds of shotgun shells and extra 9mm magazines, and exited his house. He immediately spotted Nicole and Lynn on the sidewalk walking their dogs. He ran towards them, ambushed them with multiple close-range shotgun blasts to their torso, head, and necks, and then he shot Nicole in the head with a 9mm pistol. He shot Sammy, her dog, with a pistol as well. Defendant then headed to the Greenway. Jogging through the neighborhood, he encountered Gabe, the Raleigh police officer, leaving his home to start his evening shift. He shot Gabe in the head and neck at close range with 3 shotgun blasts. Continuing on to the Greenway, defendant encountered Mary Beth, and again, at close range, shot her with 2 shotgun blasts at close range to the head and neck. Finally, a bit further down the Greenway, defendant came upon Sue and shot her at close range in the head and upper torso 3 times with his shotgun. It is quite frankly hard to conceive of a greater display of pure malice than the conduct of the defendant in his indiscriminate targeting and brutal killing of 5 innocent homicide victims on October 13, 2022. Malice is one of the elements of first-degree murder. It is defined under our law as meaning not only hatred, ill will, or spite, as that is ordinarily understood. To be sure, that is malice. But it also means the condition of mind that prompts a person to intentionally inflict damage without just cause, excuse, or justification. And quite frankly, it's hard to conceive of a greater display of malice than what I've just described. Second, defendant's crime were the product of months of fantasizing, planning, and preparation, and not the product of transient immaturity, such as impulsivity, peer pressure, or poor decision-making abilities, and cannot be viewed as being significantly influenced by neurodevelopment differences of development of a 15-year-old as opposed to the brain of a fully mature adult. In this regard, the court finds that the internet search history is to be probative of the long-standing and persistent interest of the defendant in spree shootings, school shootings, mass murders, bomb attacks, assault weapons, and notorious mass murderers. For example, from July 20 to January 21st, the defendant repeatedly searched for information on Eric Rudolph, who committed bombings of abortion clinics in the 1996 Olympics. His searches sought information on Rudolph's hiding in the mountains, why he bombed, and how did he make his bombs, including searches for images of Rudolph's pipe bombs. From January 2020 to November 2021, defendant made many internet searches researching how to build bombs and explosives. Notes hidden in defendant's bedroom included rudimentary schematic drawings of homemade bombs of various designs, such as ones detonated by a tripwire or by a phone or upon opening a package, or a pipe bomb. He wrote detailed handwritten recipes for the manufacturers of explosives like ANFO and dynamite. For the 2 years leading up to just a few days before defendant's October 13, 2022 murders, defendant consistently conducted internet searches on mass shootings and school shootings, included searches for the fastest school shooting, the deadliest school shooting, the deadliest middle school shooting, all school shootings done with a pistol, and a list of school shootings that killed 10 people or more. In the 2 months immediately prior to the murders, defendant's searches became more prescient. During this 60-day time frame, defendants queried whether someone can talk if their voice box is cut out. Do most people scream after being stabbed in the neck? Can you hear someone shoot a .22 inside their home? How fast does a .22 have to go to penetrate a skull? On August 30, 2022, defendant searched humans destroying the planet. And on September 26, 2022, defendant also searched for mass shooters who hate humans. He queried, how much does 100 shotgun shells weigh? On October 1, 2022, he asked, how deadly is double-aught buckshot? And on the same day, do police go into the woods by themselves to pursue someone? This written evidence, namely the evidence of research and planning conducted by the defendant in the months and most notably immediately prior 60 days, is closely mirrored to the actions carried out by the defendant on October 13, 2022. After 7 months of researching Eric Rudolph, who was the mass murderer who committed acts of terror and evaded capture for many months by hiding in the woods, defendant, on October 13, packed a survival bag and headed into the deep woods after committing mass murder. After researching the lethality of double-aught buckshot, on October 13, defendant chose that as his instrument of murder. After researching the weight of 100 shotgun shells, on October 13, defendant packed approximately 100 shotgun shells to carry with him for his escape. After researching whether one could hear a .22 fired inside his house, on October 13, defendant shot his brother with a .22 inside their house. After researching whether someone could talk if their voice box is cut and whether a person screams when stabbed in the neck, on October 13, defendant stabbed his brother in the neck over 50 times, and a reasonable inference from the evidence is that he attempted to cut James's voice box out. After researching mass shooters who hate humans and humans destroying the planet, on October 13, defendant wrote a note he left after murdering James saying defendant hated humans because they were destroying the planet. These facts reflect a defendant who for many months, and certainly several months prior to committing murder, fantasized, researched, and planned his criminal acts and his escape. On the day he committed the murders, he confirmed his sanity, his culpability, and his lack of regret in a written note. This lengthy period of premeditation and deliberation, when coupled with the pure malice displayed towards his random and innocent victims, are compelling findings that support the conclusion, or a conclusion, that Austin Thompson is one of those rare juvenile offenders whose crime reflect irreparable corruption. Third, the court finds that the defendant was an intelligent person with the ability to fully appreciate the consequences and risks of his actions, and did indeed appreciate those consequences. By all accounts, from defendant's parents, his teachers, defendant was highly intelligent and inquisitive person. He suffered no apparent mental health defects, no developmental disabilities, no health issues. A frequent research topic of defendant's internet queries related to consequences for various categories of criminal conduct: homicide, rape, bank robberies, assaults. Indeed, in the months prior to the murders, defendant specifically researched: can juveniles get life without parole? And how many years is a life sentence without parole? Defendant, after killing James, wrote a note. He says he shot James and stabbed him, and that James stopped breathing 10 or 15 minutes later. He wrote he killed James because he would get in the way. He said he was not bullied, that he was not mental, was sane when I did this, he was not suicidal, that he did not want to die, but that it was going to happen. He wrote he had no regrets. He tore a corner off the note and wrote, "James is dead, don't look inside," and placed it near the bathroom door with the spent .22 cartridge casing from the bullet James was shot with. This evidence, a manifesto of sorts, supports a finding that defendant clearly understood the risks associated with his planned course of conduct, including life imprisonment or his own death, and further felt it important to document the intentionality of his actions, his lack of regret, his motive, and to negate defenses such as insanity, suicidal ideations, bullying, and other factors which might be used to excuse his conduct. Fourth, the court finds that the evidence and the record before the court does not support the conclusion that defendant was experiencing a neuropsychiatric side effect of acne medication, minocycline, resulting in disassociation or confusion at the time these crimes were committed on October 13, 2022. The evidence establishes that for a year prior to October 13, 2022, defendant was prescribed minocycline, an antibiotic commonly used for the treatment of acne. Minocycline has been widely used and prescribed for over 50 years. Dr. Corvin, an expert accepted by the court in the field of forensic psychiatry, noted that an uncommonly observed side effect is an association of minocycline with a range of neuropsychiatric side effects, up to and including confusion and dissociation. He noted that defendant had no other known risk factors for such episodes, nor had he experienced any such symptoms previously. Dr. Corvin speculates that defendant's conduct and writing, coming from an otherwise more or less normal adolescent male, elevates concerns that his conduct may have been influenced by a medication-related side effect, such as dissociative symptoms. But Dr. Corvin then added, unfortunately, given the severely limited data set available for consideration regarding his state of mind on the date of question, he, Dr. Corvin, is unable to offer an opinion with a reasonable degree of medical certainty as to whether or not Mr. Thompson was experiencing dissociative symptoms on the date in question. But these observations are offered for consideration to the trier of fact, in the hope that they will be of assistance during the disposition of his charges. Dr. Nuruddin was also accepted by the court as an expert in forensic DNA and serology. He undertook to answer the question of whether defendant's ability to metabolize minocycline could have been altered by his genetic background and consequently increase his risk of experiencing side effects. Dr. Nuruddin explained that minocycline, like most drugs, is metabolized by subunits of the liver cytochrome P450 system. He further explained that specifically subunit CYP3A4 of the P350 cytochrome is involved in the metabolism of minocycline. He hypothesized, therefore, that perhaps defendant had a genetic deficiency in the CYP3A4 subunit that would impair his ability to metabolize minocycline, thereby making him more susceptible to its side effects. His experiment did not prove his hypothesis, but in fact proved the opposite. After extracting defendant's DNA and having it forensically analyzed, Dr. Nuruddin found the defendant had a normal CYP3A4 subunit and hence no scientific evidence of genetic inability to metabolize minocycline. Based upon that, Dr. Nuruddin could only speculate that perhaps further clinical and genomic studies in the future will shed light on whether any other features of defendant's DNA profile might increase his risk of minocycline side effects. The court also finds, based on the testimony of Dr. Corman and Dr. Nuruddin, that the risk of dissociation side effects from minocycline is infinitesimally rare. In the 55-year history of the widespread usage of the drug, only 2 cases are reported with any details in published studies, and perhaps 40 cases of depersonalization and derealization disorders associated with persons taking minocycline have been tallied without accompanying data on a website maintained by the World Health Organization. Dr. Nuruddin said that of the very few cases of dissociation reported, it is more prevalent in females and occurs within several days of starting to take minocycline. Moreover, neither expert was aware of any connection between dissociation attributed to minocycline and any violence, homicide, or criminal conduct. Finally, in evaluating expert opinions, the court, as the finder of fact, is not required to accept an expert witness's opinion to the exclusion of facts and circumstances disclosed by other testimony. The court must evaluate the reasons, if any, given for the opinion, whether the testimony is supported by facts that the court finds from the evidence, whether the opinion is reasonable, and whether it is consistent with other believable evidence in the case. Here the court finds and concludes that the theory that the defendant was overtaken by dissociation on October 13, 2022, at the time he committed the murders, is belied by other facts and circumstances established in this case, including the months of research, planning, and preparation conducted by the defendant, both before and after he was prescribed minocycline, the methodical and deliberate conduct displayed by the defendant before, during, and after the killings, the video footage of the defendants during the course of the rampage, and the written record of defendants' thoughts and actions. The court finds that the theory of minocycline-induced dissociation is not supported by the evidence and is rejected by the court. So, concluding, as I've noted earlier, these findings are not intended to be the final order of the court, nor have I attempted to speak to other mitigating circumstances considered by the court in making its judgment. The final order will contain details on each of these findings, as well as each of the other mitigating circumstances considered and weighed by the court in reaching these conclusions. And having carefully considered all of the evidence presented in this hearing, and carefully considered all of the mitigating circumstances offered by the defendant or otherwise found in the evidence, The court concludes that the answer to the issue before the court at this hearing is yes. Austin Thompson is the rare offender whose crime reflects irreparable corruption. And I shall now enter judgment accordingly. Mr. Thompson, I'll ask that you stand. First of all, let me ask, is there a stipulation that the defendant has a prior record level 1 based on no prior record?
Yes, Your Honor. If I've been approached, we have it written.
Yes. And let me just verify. I'll get to this. So. All right. Mr. Thompson, this time the court is going to enter judgments in this case. There will be several judgments entered. For the first-degree murder of James Thompson, I'm ordering you incarcerated for a term of life without the possibility of parole in the custody of the Department of Adult Corrections. That's an active sentence. For the murder of Nicole Connors, I'm ordering that you be sentenced to life without the possibility of parole in the custody of the Department of Corrections. That's an active sentence. It's consecutive to the judgment I just imposed. For the first-degree murder of Gabe Torres, I'm ordering you incarcerated in the custody of the Department of Adult Corrections for life without the possibility of parole. That's an active sentence. It's consecutive to the judgment entered immediately prior. For the first-degree murder of Mary Beth Marshall, I'm ordering you to the custody of the Department of Adult Corrections for a sentence of life without the possibility of parole. That judgment is consecutive to the previously entered judgment. And for the murder of Susan Carnatz, I'm ordering you to the custody of the Department of Adult Corrections for a sentence of life without the possibility of parole. It's an active sentence consecutive to the judgment previously entered. For the attempted first-degree murder and assault with a deadly weapon with intent to kill, inflicting serious injury on Lynn Garner, I'm consolidating these offenses into a single judgment. And Mr. Latour, is that a B2 felony, the attempted first-degree murder?
Yes, Your Honor.
Yes. Ordering you incarcerated for a term of 157 months minimum, 201 months maximum in custody of the Department of Adult Corrections. That judgment is consecutive to the judgments previously imposed. And finally, for the attempted first-degree murder, assault with a deadly weapon with intent to kill, inflicting serious injury, and assault on a law enforcement officer with a firearm, I'm consolidating those offenses into a single judgment. And this is for victim Casey Clark of 157 months minimum, 201 months maximum in the custody of the Department of Adult Corrections. And that judgment is consecutive to the previously entered judgments. And that, sir, is the judgment of the court.
Your Honor, at this time, the defense enters notice of appeal and requests that the appellate defender's office be appointed.
So noted. The appellate defender is appointed to represent the defendant from this point forward.
Thank you.
Thank you.
Thank you.
Your Honor.
If there's no further business for the court, we are adjourned. We are adjourned. Yes, sir.
All rise. Oh yes, oh yes, oh yes. This Honorable Superior Court for the County of Wake now stands adjourned. Sine die. God save the state and this honorable court.